Hello, everybody. This is Dr. Cole. It's Sunday afternoon, October 26th, and this will be the Week 11 announcement for Constitutional Law, Political Science 3753 for the fall 2025 term. Okay, everybody, what we have on the syllabus for this week is the class notes for lectures 19 and 20 on freedom of speech. On Thursday, everybody, we'll take quiz 5. And I've sent you some material for an issue that really is not on the syllabus, but has come up now during the second Trump administration. That is freedom of speech rights for non-citizens. You may have heard the Trump administration has undertaken deportation proceedings against individuals who have been involved in demonstrations and other activism against Israel and on behalf of Palestinians during the conflict over the Gaza Strip that has erupted going back to October 2023, of course. And a ceasefire has just been declared there in the past couple of weeks. So, see what you think of that material. There's 3 articles to read, and I expect a total of 10 true-false items on those on Thursday. Okay, you'll have 10 minutes to take the quiz once you begin it. What's at issue here is, on the one hand, several provisions of the Constitution speak of persons rather than citizens, which makes it sound as though our constitutional rights apply to everybody in the country, whether they are citizens or not. At the same time, the government has discretion over whom to deport. Okay? But what if they are deporting somebody for something that they said? Okay, now that raises some knotty problems and issues, and you will read about that in these 3 pieces we've asked you to look at, and we'll take a quiz on that. Be our 5th quiz this Thursday the 30th. You can take it anytime, 24 hours on Thursday the 30th. 10 minutes once you begin. 10 true-false items on those 3 articles we're going to ask you to look at. Okay. Now, everybody, constitutional law of free speech is more complicated than you might realize. There was a Supreme Court justice decades ago, I believe that was Justice Hugo Black, who didn't think the Supreme Court had been consistent or faithful enough in its interpretation of the First Amendment because he insisted no law means no law. Well, we haven't, in our tradition, going quite that far. Freedom of speech is subject to regulation. We, of course, want to be careful in our regulation of it, in such a way that we continue to protect freedom of speech in general. Now, looking at Lecture 19, national security is a justification that often would be given for restrictions on freedom of speech, and that may be the case with the actions of the Trump administration. You'll read about the 1919 case of Schenck versus United States, where Justice Oliver Wendell Holmes laid down the clear and present danger test. That is, if there's going to be a restriction, there has to be a clear and present danger. Now, there is another constitutional test that's been offered called the bad tendency test, which sometimes is described as the government having the right to extinguish a spark before it becomes a flame. So under bad tendency, that doesn't have to be a clear and present danger. Now, these doctrines are out there in the law books that have been laid down in the precedents in the cases the Supreme Court has taken. Okay? And the court can set these aside or grab hold of them according to its own discretion. Perhaps the predominant standard that's been used has been Justice Holmes' clear and present danger test. Okay. In Gitlow versus New York, they upheld a restrictive statute, that's a 1925 case, but they did say in that case that the right of free speech, First Amendment rights, are applicable to the states through the due process clause of the 14th Amendment, just using the doctrine of incorporation to cover free speech at all levels of government in the United States. Okay. Now, the right of free speech has been taken to include associational rights, and that's come up as an issue when people have belonged to what have been suspected to be subversive or communist organizations, and in some cases have been litigated over that through the years. But by and large, your right of free speech does include associational rights to cooperate with people whose views are similar to your own. Regulation of speech. In Brandenburg versus Ohio in 1969, that was a case that involved members of the Ku Klux Klan. And in that case, what the court said is that you can advocate violence as a doctrine unless the speech is intended to immediately bring about violence. Okay. But you can advocate violence as a doctrine, even teaching that the government ought to be violently overthrown as a doctrine, as long as you are not attempting to immediately incite violence. Okay. Now, public employees, free speech rights of public employees are something of an issue. The Hatch Act, going back to 1939, endeavored to regulate the behavior of public employees. The Hatch Act reform amendments of the 1990s afforded public employees free speech rights outside of the workplace, and as long as they weren't wearing the uniform of a public employee. Okay. Patronage, the case of Rutan versus the Republican Party of Illinois, laid down the doctrine that employees could not be disciplined, public employees, for exercising their free speech rights. And that case often was interpreted as going so far as to outlaw patronage decisions about public employment. The late Justice Scalia said in a dissent that justices of the Supreme Court really owed their jobs to patronage, because presidents generally appoint members of their own party when vacancies come up and have to be filled with appointments or nominations to the Supreme Court. The fighting words doctrine in regulation of speech. This is the doctrine that you can regulate speech that seems to be intended to immediately provoke a fight or an altercation of some kind. Now, the matter came up in the case of RAV versus St. Paul, 1992, which was a case in which someone burned a cross on the lawn of an African-American family in St. Paul, Minnesota. But the Supreme Court struck down the statute that was used to prosecute the person who had burned the cross, because it was a so-called hate speech statute. Okay? And what the court said was that they really went too far in attempting to regulate or prohibit hate speech. Now, this came up very recently with regard to some of the Trump administration's actions. Attorney General Pam Bondi got herself in a little bit of trouble, which she suggested that the administration was going to try to prosecute people for certain types of hate speech. But RAV versus St. Paul is generally taken as saying you can't really have a hate speech doctrine because that runs afoul of the First Amendment. So the Attorney General had to walk her comments back. Now, content moderation 09, we've mentioned a couple of cases, including Murphy versus Missouri, 2024. And this goes to actions that the Biden administration took in their communications with the companies that ran some of the online platforms such as Facebook, Instagram, others, Twitter, attempting to combat the spread of misinformation about the COVID pandemic. And what the court found in this case was that the online platforms were the property of the companies who ran them, and so they were entitled to exercise content moderation on those platforms. It was controversial because it was argued that some of the content moderation was done in response to political pressure applied by the Biden administration, and it came out in public. Actually, Elon Musk had a hand in revealing some of the communications that had taken place between the Biden administration and the people who run some of the social media platforms that were involved in this case. Symbolic cases, symbolic speech. The famous Tinker versus Des Moines case, 1969. The court upheld the right of high school students to wear black armbands in protest of the Vietnam War. Texas v. Johnson, 1989, was the famous flag burning speech, which the court found the act of burning a flag, not a case of literal speech, but a physical act that was held to be tantamount to speech, was protected by the First Amendment, and there were efforts to overturn that decision by constitutional amendment that were not successful. Okay. Speech plus, the Thornhill versus Alabama decision involved picketing, which they extended First Amendment rights to cover activities like picketing. The Pune Yard Shopping Center case, that was a case that involved the Constitution of the state of California, which actually granted more in the way of free speech rights than the United States Constitution does. And under that provision, the Supreme Court said if California wanted to protect the right to distribute pamphlets or circulate a petition in a privately owned shopping center, California then could do that. So a state can provide even more extensive free speech rights than the federal government does if it so chooses in its laws. Now, finally, everybody, we have the matter of campaign financing and the issue of whether money equals speech. So that if you restrict the amount of money that can be spent in an election campaign, you restrict spending or you restrict donations, is that tantamount to a limitation or a violation of the freedom of speech? Now, the Supreme Court said yes up to a point, and the very important decision here is the Citizens United decision of 2010. And we have to be careful about what that decision did and did not do. Okay. They allowed regulations, okay, for the campaigns of individual candidates or of political parties. But what about independent expenditures that were not done by individual candidates' campaigns or by political parties, but by independent organizations in support of a party or a candidate? That could not be restricted. Okay? And that has led to the rise of organizations called so-called super PACs, okay, whose spending activities cannot be restricted under the Citizens United decision. It's really a decision that accepts up to a point the notion that money equals speech. Okay? Parties and individual candidates' campaigns can be regulated, but not independent organizations that are not part of a party or an individual candidate's campaign. All right, so that is it for the notes for lectures 19 and 20 on freedom of speech. Quiz on Thursday, quiz number 5. We'll get 3 pieces to which we've sent you the links having to do with the freedom of speech rights of non-citizens in the controversies that have erupted over under the Trump administration regarding activities by non-citizens in behalf of the Palestinians and against Israel. So we'll take that quiz on Thursday the 30th. And we'll talk to you about freedom of the press next time, about a week from now. Good luck on the quiz, and we'll talk to you once again in a few days.